There is one matter on the list this morning, Your Worships, being the case of Miss Susan Bridgeford, who has pleaded not guilty to a charge of driving with excess alcohol. Mr Hucknall appears for the CPS and Miss Mirren is for the defendant. Miss Bridgeford, could you confirm your full name, date of birth and address, please?
Yes, it's Susan Mary Bridgeford, born the 25th of the 7th, 1986, currently living at 12 Waterloo Villas, Eastwick.
Thank you. Now, you're here in connection with a charge of driving with excess alcohol on the 13th of February this year, and you've previously entered a not guilty plea to that charge. Is it still your intention to plead not guilty today?
Yes, it is.
Miss Bridgeford, if you'd like to sit down, please feel free to do so.
Your Worships, I have an application in this case. As you may be aware, the single issue is whether the officer conducting the breath test procedure gave the defendant the statutory warning under Section 7, Subsection 7 of the Road Traffic Act 1988. This provision states that the police officer must, on requiring a person to provide a specimen for analysis, warn them that a failure to do so would render them liable to prosecution. If the prosecution can't prove that to the criminal standard, then regardless of what other evidence there may be, the defendant must be acquitted. As the court will see from the case management form, PC Hardwick, who was the officer conducting the breath test at the police station, was required to give evidence. Now, the Crown yesterday received an email from him indicating that he's on an important firearms course and cannot attend today's hearing. The Crown served his statement on those who represent the defendant, seeking their agreement of it, but they cannot accept it. And so we must therefore ask for an adjournment so that the officer can attend. Obviously, we regret the fact that this officer is not available, but would point out that this is the first time the matter has been listed for trial, and I would submit that the defendant will not be prejudiced by any adjournment of the case.
Thank you, Mr Hucknall. Can you tell us when this crucial witness was warned to attend court?
Well, I regret that it appears that because of an administrative error, the usual notification was not sent from the witness care unit immediately following the last court hearing, and therefore he was only warned to attend about 10 days ago.
Miss Mirren, do you have any observations on the prosecution's application?
Well, sir, I clearly don't support the application, but these things happen, and it is right to say that this is the first time that the trial has been listed. At the end of the day, sir, it's a matter for yourselves.
Thank you, Miss Mirren. Miss Rydell, what would be the next available date if the bench decided to accede to the Crown prosecution's application? And is there any advice you could give us about these cases?
Well, yes, sir. In anticipation of this application, I have already contacted Listing, who say that the matter could be listed in approximately 8 to 10 weeks' time. As far as the merits of the application are concerned, Ms Mirren is quite correct when she says that it is a matter for your discretion. There are a number of well-known cases on these situations, and the higher courts have confirmed that whilst it is not possible or desirable to identify hard and fast rules as to when adjournment should or should not be granted, applications for adjournments must be subjected to rigorous scrutiny. In the case of Aravinthan Visvaratnam versus Brent Magistrates Court, 2009, Mr Justice Openshaw said, and I quote, "Trial should not be adjourned unless there is a good and compelling reason to do so. The sooner the prosecution understand this, that they cannot rely on their own serious failures properly to warn witnesses, the sooner the efficiency in the magistrates' court system improves."
Thank you. Well, what do you think? Should we adjourn? Or should we adjourn? Or should we just tell them to get on with the day or refuse the application? Not to refuse them. Okay, fine. Thank you. Well, we've considered the failure by the Crown properly to warn its crucial witness. We've also taken account of what would be fair to both sides. We've taken into account also the delay in fixing a new trial date. We've taken notice of the advice given to us by our legal advisor in relation to the Brent Magistrates case. And we are satisfied that there is no good or compelling reason for this matter to be adjourned. and so therefore the Crown's application is refused.
Well, in light of your decision, the only option that I have is to offer no further evidence and invite you to dismiss the case.
Very well, we now dismiss the case.